Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up For You. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Fantastic show lined up for you today. In a few moments, we will speak with Ken Johnson. He's a professional mediator in the state of Florida and has lots of good information about mediation services to provide. Before we get there, Deborah, what is on your mind today?
Let's talk about the state of Missouri. Let's put them on blast. The Missouri legislature, the most recent session, the leadership in this legislature, they didn't even bother to consider a bill that would have extended by at least 10 years the statute of limitations for a child who was sexually assaulted to sue their attacker in court. Currently, the Missouri law, you can sue someone after 10 years. The statute of limitations ends 10 years after the 21st birthday or 31 years old. So you get to be 31 years old, you can't sue anymore. You can't sue that attacker. And the bill that they proposed would have extended that to at least 10 years so that when the person becomes 41 years old, they can, before they become 41 years old, they can sue. But they didn't even consider that. And it turns out that a victim of assault typically won't even start talking about it or dealing with it. The average age is like 52 years old. And so they're not even close to really dealing with childhood sexual assault or childhood abuse in that way. And so it's really very disappointing. It's basically a win for pedophiles.
That is so unfortunate. That is a shame, and it's what's admirable about this story is that people actually did the research. I'm sure I showed the court, those stats about when people start talking about it, right. And still you can't get any action from the legislature. That's unfortunate. Good to put them on blast, and hopefully they'll be able to reconsider that when there are some more sensible people in office there. So, absolutely. Yeah, good. All right. Well, at Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you're in court without a lawyer or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com and try it today. All right. With that in mind, I'd like to welcome to the show Ken Johnson, a professional mediator there in the wonderful state of Florida. Ken, welcome, and thank you for joining us on Who Wrote That Up For You.
Thank you. It's great to be here.
Fantastic. Let's get a bit of background from you. I have very limited experience personally with mediators, but I've heard some really good things about the services you provide. What is the role of a mediator? How do you sort of interact with the litigation process, civil litigation process?
Well, there's a lot of jargon involved with mediation, kind of like lawyers, they have their own jargon. We have our own jargon as well. So I'll try to simplify it. Everything that we do is under a thing called ADR, or Alternative Dispute Resolution. And alternative dispute resolution, it covers a multitude of different fields of study. Arbitrators, like Judge Judy that you see on TV, she's an arbitrator. If in some cases you might deal with somebody called an ombudsman or ombuds, totally different field. Sometimes you'll deal with restorative justice practitioners, especially if there's a juvenile involved and you got a community-based response. That's something I'm also trained in. And then you got mediation as one of the more well-known ones. Mediation, there's different types. The one that I practice is a thing called facilitative mediation. And so in the state of Florida, and I do other places as well. So I mediate for USDA, I mediate in Hawaii, I do a bunch of different mediations. But with facilitative negotiations, I am a impartial third person. And so when I get to your case, I do not know who you are as a person. I do not know really much about the case. And my job is to help the parties to work out an agreement if at all possible. And this is done in a safe space. Everything is confidential. So I had one mediation a while back, and they had said some stuff that after we got everything handled, I could tell that they felt kind of ashamed and worried about what they said. And I had to reassert, I'm like, in Florida, if a judge calls me in and wants to know what happened, I'll have to respectfully let them know they need to get bent. Um, and I use that phrase because these were people that terminology would resonate with them. And they, to let them know that I do have a set of values, I have a set of morals, and the law gives me that authority. Now, I would say it very nicely when I'm in front of a judge, of course, but that would be the gist of it. And so all I do is we take an issue and we work through that issue, and so long as the parties uh, continue to agree to work with each other, and my job is to help empower them and help them to see issues with their thoughts and potential pitfalls with their plans. So I do little devil's advocate work, a lot of devil's advocate work. Sometimes, if they're not behaving themselves, I'll throw them in timeout. I'll do whatever I need to do, and from there, we'll write up an agreement. If we write up that agreement, that was your day in court. That was your chance to say what you wanted to say and do what you wanted to do. 90% of the time, or better, the result is better than what you would get with a judge. Now, I don't know what a judge would do, but at least the clients tell me that they felt that they got better. So I can't say it's on my own that's what you would get, because I'm not a lawyer and I can't say what a judge is going to do, but usually they feel that it's better than what they was expecting. It's faster, it's cheaper, and in the end, the chances of somebody following through because they actually helped draft up the document and the contract is extremely high. I think like 80-something% of the contracts they're drafted by the people are actually followed through. Whereas if a judge orders it, I used to work in the court system. People would come to me and they say, I have a judgment, I have a judgment. And I'd say, great, you have a piece of paper. Congratulations. Because the
Yep.
enforcement of that paper can be very difficult depending on where you live. So it's good to have the parties actually, say, I drafted this document, so now I'm going to comply with the document.
Absolutely. You've served up a lot there. I want to unpack a
Okay.
good bit of that. One of the things you mentioned is the law around mediation, some of your professional responsibilities there. So I can't just walk into, a courtroom and say, hey, I'm a mediator. You have to be certified in some way, go through some training. Can you talk a bit about your background and how you got to this point?
Well, you say that you can't walk into a mediation and say, I'm a mediator and I want to mediate, but actually, yes, you can. The law is that crazy. So now I am properly certified. So that means that in addition to having a graduate degree and undergraduate degree in social sciences, years of training, all the continuing education, going through I'm certified with the Supreme Court of Florida for county family circuit. I'm certified with the USDA. I'm certified through the chief financial offices for state of Florida. I've got all these different certifications. The law is very clear that if the parties agree that a person they want to use somebody, let's say you got a barber and you want the barber to mediate your divorce, the barber can be the mediator, but the barber has to comply with all the rules that a mediator must follow. So, I mean, it's really strange how the laws are with that.
What are some of those rules?
First thing, anything that we say and do except where I'm required or permitted by law to report is confidential. So, in very rare circumstances, like for instance, if I find out that somebody is being violated and it's a pedophile case, I am required by the state of Florida to speak up. I cannot stay silent. But other cases, let's say I'm going to kill them after this mediation case, that is not protected as far as required, but I am permitted to report. But something about oh, they're doing this or they're doing that. A lot of that's protected. I can't say anything. And if you say something to me while we're trying to schedule mediation, even those early talks, trying to get the meeting scheduled, all that's protected. So I have this huge veil of confidentiality. And in the state of Florida, I have the highest level of confidential privilege that they award, which is judicial confidentiality. So that means that not even a judge can ask me what happened. And
Fantastic. Are there also conflict requirements? In other words, can the barber
yes,
be the a brother or a relative of one of the parties in the mediation, or something like that?
being a disinterested third party is critical. So that means that I cannot know the parties. Now, there are exceptions. For instance, a lot of stuff I do is contract work. So that means that there's a ton of attorneys that I'm going to deal with. There's a ton of insurance companies I'm going to be dealing with. And I may know somebody on their ADR team that I've had tons of work by. They're just the agent and I'm just mediating the case out, but I don't have a relationship with those people. I don't go and eat steaks at their houses or anything of that nature. They just know me in a mediation capacity. So it's as long as it's certain professions, we can know each other, but we can't go very much outside of the mediations itself. So I wouldn't show up at a attorney's Christmas party. That would be a no-no. But I might have done 100 mediations with that attorney, but I can't have any sign that I'm being partial.
You remind me, I remember the Rocket Docket foreclosure issues back in the day. And that a lot of homeowners were complaining that the judges might have had, through their retirement funds, some kind of relationship with the bank that had the mortgage, right? And so they were
Mhm.
trying to get judges disqualified right and left and that sort of thing. And nobody was hearing it because it was a distant relationship. Just because the judge has stock in Chase or whatever bank, they don't have a relationship that would bias them in that case, right?
Mhm.
And this is sort of a similar, if I'm understanding you correctly, you might get business from some particular insurance company, but that doesn't necessarily bias you if the insured or somebody is one of the parties in your mediation. Is that am I on the same? Am I?
That's pretty much it. And we have to be careful how we do this to make sure that we're not biased. And a lot of it weighs heavy on where that line is the mediator sees. But we do have a division that with the Supreme Court of Florida that if you have a problem with us and you feel that we violated some type of ethics or whatever, then you can go there and they can make me break my seal of confidentiality. They're the only ones that can make me break my seal. And then
Interesting.
but when you do that, if it's found that I'm innocent, do know that I can go after you then, because you made me break the seal, and everything that I said is now used as evidence against you. And
Wow.
because, I have to protect myself like any profession. And so you have to be aware of that. But yes, if you think a mediator has done wrong, go after them. But just realize you better have your stuff together, and it better not be a frivolous case, because it could backfire on you.
Absolutely. Absolutely. And so you mentioned that mediation and arbitration and ombuds processes are all part of alternative dispute resolution. And this would be an alternative to the regular litigation process, right?
Right.
Do the parties generally decide to go to mediation themselves? Or is it more often court ordered to get this thing, at least temporarily, out of court? How does it typically go?
Well, it again, there are so many different opportunities to mediate that, outside of the court, like USDA. Anything that the USDA does, because I'm a USDA mediator, if they ever reject anything at any point in time, you can say, I want to talk with a mediator, and they will pay for it. All you got to do is say, hey, look, I want to mediate. Like I was telling Deborah, before we went live, that, if your house gets blown away, you can go to the CFO's office, say, hey, look, I want a mediator, and the insurance company has to pay for that. But most people don't know that. In fact, most people don't even know what I am, what I do, anything about my profession. And so a lot of times it is through the court, and the judges, they're inundated. I mean, you think about how crazy that it is in the court system. Most people, unless you've worked in it, you really don't know how nutsoid it really is. And so the judges are trying to get as much off of their docket as they can. And so the judge will order it. And so a lot of that stuff can be resolved if the parties wish to resolve. But in the state of Florida, if I have to do an opening statement, that's required. And so my basic opening statement is who I am, what mediation is about, the confidentiality stuff, talking about where I'm required or permitted by law to report. I actually have to say that. I've got it memorized because I'm required to say those words. And once I've done that, they can say, okay, I don't want to mediate. And we can do a thing called impasse. And impasse means no agreement. Another one of those terms I told you about. And then it goes straight to court. And there's some people that they want their day into court, and they don't care if they're going to lose money. They believe strongly that the court system is where they're going to find their idea of justice, whatever justice is. But other
Yeah.
parties, they wish that, well, I want to do the alternative. Let's give it a shot. And for those people, most of the time when they do the surveys and things of that nature, the information I get back, they're surprised at what they was able to do. They were shocked. They didn't believe that they could get what they got. And long term, if the agency I do does a long term follow up, they're very happy. So
Fantastic.
they felt they got justice. They felt they got more than justice.
At what point in the litigation process do you find a judge ordering mediation? Is it at, as soon as the complaint is filed, or maybe all the pleadings that have closed, or is it after discovery on the eve of trial? Like, where in the litigation process do you typically see a judge say, okay, I need y'all out of my court, go over here and mediate this thing?
It really depends. In, like, for instance, in a divorce case, which those are the worst, because you got two people that usually just hate each other. And I try to do a little bit of a pre-mediation conference to kind of coach them a little bit. And I'm like, you really need to work with each other. The more you can get done, the more we can get done. If if you're able to see the other side as a human being, that's the hard part. Just see the other side as a human being and work with them. Say, hey, look, we're no longer together, but let's work this out. Let's try to find some type of equitable distribution and try to work it out. Judges won't order the mediation because, hey, you've done all the work that's required of you. But if you're fighting, if you don't, if you, you know, the paperwork's not done, there's no agreement, whatever, the judge is almost going to always kick it to mediation from the start. So a lot of times you won't even get the first hearing with a judge, you know, because they have, at least in Florida, there's different hearings. You got preliminary hearings and all that. A lot of times you don't even get. I've been in court, and you know, the preliminary hearing was, who are you? Who are you? Here's your mediator. There you go.
That's fantastic. That is fantastic. So now, do you find that mostly in family court, or, so I know you do, you know, you mediate a wide variety of claims.
Mm-hmm.
And family court, you're probably dealing with two pro se's, most often would be my guess, right?
Mm-hmm.
Do you find that in other types of claims outside of family court?
An amazing amount of the work that I do is pro se, which I want to break down pro se because that part of my job is to break down jargon. And so pro se just means that you are representing yourself. And that is something that I never advise anybody to do, not even attorneys. So I always suggest that you seek financial counsel and you seek an attorney, because those are two areas that it's going to trip you out the most. But and then in divorce, you also need to have a special type of person to look at your retirement benefits, because some documents like your retirement benefits and your mortgages, even though judge says, hey, look, you know, you no longer have the house, you're still responsible for the mortgage. And even though judge says, hey, look, you're going to get this retirement after somebody croaks, it may not be the case. So you know, you need to have some professional help. But most of them, they tend to be represented, if not pro se. Like, for instance, with the CFO's office, you can get a public adjuster. If your house gets blown away, your roof gets blown off, whatever. We deal a lot with hurricanes in Florida. So, you know, you got a public adjuster. They're going to argue for you and talk with the insurance company. Most of the insurance companies, they're just going to have an adjuster. Very few of them have an attorney. So even the professionals that you're going to be dealing with, in a lot of cases, no attorney.
Interesting. And so you're not required then, for a pro se litigant, you're not required to talk directly to them. They can have another representative who is not an attorney handle their mediation for them. Is that what I
Yes,
understand?
yes. So they have to be present, because
Okay.
they have to do informed consent. So
Hmm.
they have to be present, and I have to let them know, because you're not using an attorney. You should at least seek, you know, legal counsel and financial counsel and everything, but you're using a public adjuster. And for those types of mediations, a public adjuster is allowed. And so you can do that. So there are types of mediations where people are brought in. I do USDA stuff, so sometimes you might have somebody brought in that they're a consultant, but they're not a attorney, and they have no ability to give legal opinions, but they might be telling you, hey, look, you know, we know this program, and here's the guidelines in this program. Um, so you get some strange opportunities.
I can imagine. I can imagine. I would expect your job in a mediation to be easier after the discovery was concluded. If all the facts were on the table and sort of both sides understood the case that would go to trial, then your job would be to just sort of say, look, here's your situation. Here's your situation. Let's work it out. But if a judge is ordered, or the parties have decided earlier in the process to go to mediation, the facts may not be fully developed. What is your job look like? How do you handle that sort of situation to try to get these parties to a settlement, to an agreement?
Well, I'm a non-lawyer, mediator, and in the state of Florida, even if I was a lawyer, I can't give any type of legal opinion. So the idea of discovery, I find that to be hilarious. That is the facts of the case usually matter very little to me. I deal in people, I deal in emotions, and what I find to be revolting and sickening, and I wish that there was something that could be done, is that in the cases where I do have lawyers, some of the attorneys will use mediation as a way for free discovery. Because if somebody reveals something, even though it's confidential, and then they can find out through another means, they're circumventing the whole purpose of this so that they can get their discovery. And that chaps me, because they're playing a different game than what the intent is. And that's where you talk about spirit of law versus letter of law. They're following the letter, I follow the spirit. But in a normal day, my deal is to figure out what the issues are. Anytime somebody says, hey, look, this is a $40,000 case, in back of my mind, I know this is not going to be money, because there's a thing called the Lohman-Cabbage model. And Lohman is an attorney in the Netherlands, and he came up with this concept. And I write a lot, and I talk about him. Then there's another one that's called the Clausen model, and then there's my model that I created called the avalanche model. And I explained how conflict changes over time with the avalanche model. But Lohman said that if you see conflict, if you cut a cabbage head in half and you see that core, that is the real conflict. And that as time progresses, you have all these layers of leaves that are underdeveloped. And those undeveloped leaves are emotions and feelings that you cannot articulate. And then you have the outer leaves of the cabbage. And so those are well formed. And so normally that's money, because people can articulate and understand money very well. $40,000, $80,000. That's very easy to articulate. But unless it's a case where a roof is blown off or there's actual physical damage where it's a true money thing, 9 times out of 10, it has nothing to do with the money. It's because somebody got their feelings hurt. Something happened. And if I can get to those feelings and get the people to see each other as people, a lot of times it has nothing to do with the trappings of the case, as Lohman put it. It is the actual core conflict, and I'm dealing with the core conflict. And that might actually be telling somebody, hey, look, I know that this is a eviction case, but you shouldn't have married your business partner and then started renting from them. And I know you're lonely. Maybe you need to find somebody in your life that gives you purpose and work on self-help, and just walk away from a toxic situation that you've basically trapped yourself in. And so I play camp counselor a lot of times. And so the attorneys are all about, oh, I got to find this, and we got to argue this. None of that plays a role in my life. Rarely. I don't even look at it. It's laughable to me sometimes.
That is a fascinating perspective. Really, I think, first I've heard a very unique perspective on the mediation, the value of mediation as being outside the facts and just dealing with the human issues involved. I really appreciate you sharing that. Ken, we could talk about mediation. I could talk about mediation and the processes with you all day. This is very, very highly instructive. Let me ask, where could people find you online? I'm going to just put your company here, Ken Johnson Mediation. Where can folks find you if they wanted to have a mediator in their Florida case?
Simply just go email me, kenjohnsonmediation@gmail.com. If you have any type of mediation that you want to do, I can do that. If you want to do restorative justice, we can do restorative justice. So I'm trained in that. So we can help out. I do have a YouTube channel. Because of the law, I can't really say too much, so I don't do a lot of mediation stuff. But I have Ken Johnson USA is the handle for YouTube. So if sometimes I'll put out ways to handle a conflict at work or something like that. Very rare. People don't normally care about conflict. They try to avoid it, but if you want to go there, you can as well.
Fantastic. And I know, and we'll share that in the show notes here. I know you've written quite a bit about restorative juvenile justice and various alternative dispute resolution. So we'll share those resources as well with our audience. Ken, thank you so much for joining us on Who Wrote That Up For You, and we'll see you again soon.
It's been an honor. Thank you.
That is fascinating. That is a huge service, and particularly when I think about the difficulties that pro se's have generally with the litigation process. Certainly, we do everything we can at Courtroom 5, but mediation, if the opportunity is there and it's legit, and you don't have opposing counsel playing games with it, the way Ken indicated, can be very valuable for, I think, a lot of people.
That's a great perspective to see the law from as well.
It is. Exactly. Fantastic. Deborah, I know I take up so much of your time with these conversations, but why don't you take us to a close?
Okay. I'm starting this new series where I am just looking at just taking a summary view of a court case. And this time we are looking at a case from Missouri. The parties are Bob and Ruby Schutz, and the background is that Mildred, Bob's ex-wife, sued him for alimony, and he failed to pay his alimony, so she sued him for a property that he and his wife, his new wife, Ruby, was trying to transfer to himself. And the lower court found that Bob's transfer of the property to himself and to Ruby was voluntary without consideration, and that it was for the purpose of hindering, delaying, and defrauding Mildred as a creditor of Bob. In other words, Bob tried not to pay alimony payments, so he bought this house for his new wife. The lower court, that's actually supposed to be the higher court decision. The lower court decision, was that they set aside the real estate transfer in favor of Mildred, because they basically said, let's give this home to Mildred. The higher court affirmed the decision in Thomas versus Schutz. They stated that the trial court was indeed correct, that Bob basically defrauded Mildred and tried to transfer this property without paying her alimony, and that Mildred has a right to this house, and so set aside the deeds to the property and basically handed that victory to Mildred. So I basically, that is a firm decision that to me is very supportable and a very good decision based on what the facts were. And you can find that decision just by looking through court files, Thomas versus Schutz in Missouri. That's it.
I'll bet I'm noticing that's a 1983 case, and I bet Bob is still paying for that. Should have just gone and paid it up front, man. Avoided all that pain. All right, cheaper to keep it. Should have gone to mediation on that one, right? Yep. That's great. All right, fantastic. Thank you for that, Deborah. That's all we have for you today. We will see you next time.
All right. Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.